Due to increased accessibility to marijuana, there's bad news and there's good news. The bad news is that more kids are flunking out of school, but the good news is that their parents couldn't care less. So I'm going to talk about both medicinal marijuana, medical use of marijuana, and adult use of marijuana, and how it affects you as employers and what you need to know. Last July, a decision came down from the Supreme Judicial Court of Massachusetts in a case called Barbuto. And Ms. Barbuto had Crohn's disease. She used a small amount of prescribed marijuana in the evenings to stimulate her appetite. She started a new job, and after one day at the new job, she was terminated because she had failed the company's drug test. Even though during her recruitment process, she had told them she was going to fail the test because of her medicinal, legitimate, prescribed use of marijuana. After one day, they got the results back and they terminated her. They told her that they were terminating her because marijuana use is illegal under federal law, and so they had a right to do this. Due to her Crohn's disease, Ms. Barbuto was, according to the Supreme Judicial Court, a qualified handicapped worker. And you know what that means. It means she was entitled to reasonable accommodation for this disability under mass anti-discrimination law and consistent with the new Massachusetts marijuana legislation for medicinal use. Allowing an employee with a disability to test positive due to off-site use of marijuana for legitimate prescribed medical purposes is a type of accommodation that is required as long as it is reasonable. And Robert talked to you a little bit about what constitutes reasonable accommodation. An accommodation is reasonable if there's no undue hardship on the employer for allowing that accommodation. An undue hardship would exist in this situation, according to the Supreme Judicial Court, if allowing the positive drug test, presumably in violation of your normal rules, would cause the employer to violate a contract or statute. So say, for example, you're a federal contractor. A federal contractor would not have been required to accommodate Ms. Barbuto because doing so would violate their contract with the federal government, therefore creating an undue hardship for that particular employer. Federal contractors are not required to allow even off-site medicinal, legitimate, prescribed marijuana use by their employees for this reason. Another example of an undue hardship would be a company, such as maybe one of yours, that employs professional drivers, and therefore you're regulated by the Massachusetts Department of Transportation. So, for example, allowing a bus driver to test positive in violation of your standard drug testing rule, even for off-site legitimate prescribed medical marijuana, would be an undue hardship for a bus company because it's not a reasonable accommodation under the Department of Transportation rules, which prohibit positive testing for marijuana for drivers. And I know that that is a policy that's enforced aggressively by the state government, so in that case you would not have an obligation to provide this accommodation. It would not be reasonable for you. Exempting an employee from a workplace drug testing policy for off-site medicinal use of marijuana may also be an undue hardship and therefore, again, not a reasonable accommodation and not required when the position involved is what we call a safety-sensitive position. This might be, for example, jobs that require operation of heavy machinery, operation of a motor vehicle, certain warehouse jobs where you're using forklifts, where you're lifting and moving heavy pallets or boxes. In these situations, it may be an undue hardship for you because it's a safety-sensitive job to allow somebody who tests positive in violation of your drug testing policy. To be clear, this law, the Supreme Judicial Court case, applies to only off-site use, right? It doesn't apply to on-site use. As an employer, you still have every absolute right to establish a policy and strictly enforce a drug-free workplace in all instances. So again, it's just off-site use for medicinal purposes that requires accommodation within reason, reasonable accommodation in the absence of undue hardship. Now, let me move on to recreational or adult use marijuana. I can tell you from my experience that employers are confused and uncertain about recreational marijuana use, and for good reason, because it's legal under state law, it's illegal under federal law. And where the use is not for medical reasons to address a disability, as we just discussed, employers do not have an obligation to provide reasonable accommodation, so the marijuana law provides very little guidance to employers. I can tell you one thing that is clear. Again, as with medical marijuana use, employers absolutely may prohibit on-site use of marijuana and use of marijuana while on the job. You can also prohibit working while under the influence. Drug-free workplace policies are appropriate and they're enforceable. The problem is the drug testing. The problem arises with application of employers' drug testing policies. Marijuana is known to stay in the bloodstream for days or weeks, and there's no reliable test to determine, like a breathalyzer, if somebody is currently under the influence. So let me give you 5 points of clear guidance. Number 1, be clear that your employees are never allowed to use marijuana while in the workplace or on the job. Number 2, be clear that employees are never allowed to come to work or perform any job duties under the influence. Number 3, this is important. Spend time thinking through your drug testing policies, both your pre-hire screening and your random drug testing policies. Does it make sense to preclude from your workforce anyone who tests positive for marijuana? Considering how commonplace marijuana use is, perhaps limiting employment to only those who test negative for marijuana is not a good business decision for your business. Only you can decide. Think about special circumstances in which it is absolutely appropriate and in fact necessary to drug test for marijuana use and strictly enforce a no drugs policy, a drug testing policy. For example, as we discussed, you should not be employing anyone who tests positive if doing so will violate a federal contract, if doing so will violate a statute, or if a person is in a safety sensitive position, again, operating heavy equipment, operating a motor vehicle. I always remind clients, and this is number 5, that they have an absolute right to discipline and terminate employees for performance-based reasons. And I always want to remind my clients of this, because if you decide to forego drug testing for marijuana among your employees in non-safety sensitive positions, and you find that somebody is slacking off, is behaving inappropriately, is demonstrating that they can't do their job, regardless of whether it's because of their use of marijuana, legal or illegal, you've got a performance problem. And it's appropriate, therefore, to discipline, to counsel, to work with that employee, if necessary, to terminate that employee, again, based on performance reasons. That's my advice to you. Enjoy your marijuana.